Yet you pick up another case where you allegedly stomp on someone's head. You're your own worst enemy. If I let you out, I know that you're just going to continue to make a bad decision.
Welcome to Bench Report Court Cam.
Let me express my extreme disappointment with you. You've now picked up a new case. Is it on docket today or no?
It is, Judge. We placed it on after we spoke.
Mr. Foster, you now stand charged with the offense of assault. You are facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. For some reason, I don't see it.
Well, Your Honor, it's understood.
Well, Judge.
Tristan Smith, I'm sorry. I called you Foster, I meant Smith.
Can you, API, was it to be, so this is a walkthrough on the new case, the new charge. The previous one, which is the AFM, he has two open misdemeanors right now.
Right, so he initially had the open assault of a family member.
Yes.
As of December 19th, he's now picked up a new assault.
Yes.
All right, let's do probable cause.
On the new assault.
On the new one.
Yes, Judge. On October 29th, 2024, an officer was assigned to investigate an assault that occurred on the 18th of October at a residence in Harris County, Texas. The officer reviewed video footage of the assault that showed the first complainant and the defendant engage each other in a physical fight until another female assisted the defendant by punching the complainant and grabbing the complainant by her hair. The female swung the first complainant to the ground by her hair, causing pieces of her hair to be ripped off while the defendant punched the first complainant multiple times in the face. As the first complainant was on the ground, the defendant stomped once on the back of the first complainant's head, and the officer observed the first complainant with injuries based on photos. The first complainant told officers that on the day of the offense, the defendant told her that he was going to assault her once she exited her vehicle, and a friend of hers that was inside the vehicle recorded the fight. The defendant and the first complainant used to be friends, and the defendant used to live with the first complainant at her residence until the defendant was kicked out.
Judge, if I can, just utilizing the state's information that they provided, I didn't hear the prosecutor read this part, but at some point, the officer interviewed the complaining witness in the new assault. Based on what she told him is that she had heard that Mr. Smith was going to attack her. And if you just read in the DIMS, she exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. When I talked to Tristan about this last week, he told me all about it. He said, I remember this because it is a 2B. He hadn't heard nothing, any follow-up on it. This young lady got out of her car and attacked him as he was walking down the street. It says it right here. MB exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. She's in a car where she could have easily seen him and kept driving. No, she got out of her car and attacked him, exactly like he said. And while he was defending himself against her, another individual, another female, came to assist him in this fight because he was attacked and blindsided. This is exactly what the complaining witness in this case told the police happened, except she said that, well, I heard that he was going to attack me, so I jumped out my car and attacked him first. That's not an assault.
I don't know. All I know is that the facts are pretty egregious. And I mean, he could have taken off, didn't have to sit there and didn't have to engage. He could have, you're on bond for a criminal case. So stop. I'm not asking you to say anything. You, in the correct mindset, I have an open assault. It's probably a pretty good idea for me to go away and not do anything here.
And if he had that time to reflect in that instance, then perhaps he should have done that. But he's walking down the street and this girl jumps out the car to engage him in a physical fight, like she told police that she did, to defend herself from him. He doesn't have time to sit and reflect, oh, I got a case and all. He
could have run away. He could have gone. He could do something else. I don't know.
Being attacked, Judge, you got to do something.
Look, I get that there's always two sides to the story. But I'm going to find there's probable cause now.
I understand.
If you develop something later, if you see something on video, if you show something that she's the initial aggressor, come back and we can talk.
She said it. She told the officer.
I don't know that for sure. I mean, it just,
Let's say in self-defense.
Yeah, we have in self-defense, and then we have furthermore that once the female was assisting the defendant, that the defendant continued to assault the complainant, even stopping the complainant on the head.
You got to stop her if she's attacking him.
Well, Judge, she was down on the ground. The complainant was down on the ground, and the defendant stomped on her face.
I'm finding that there's probable cause. You picked up a new case.
And we'll deal with that, Judge. But the biggest issue, of course, is the fact that he did pick up a new case, albeit he didn't ask for it. I mean, he's walking down the street. And his situation being one that's extraordinary, one that I haven't seen much this year, dealing with indigent defendants, being of his age, which is a high school student, as we've talked about before, pending graduation with an acceptance to a great school. This is a very tenuous time for him. You've already ordered him to be drug tested before and all of that. So we're working through those things. The last thing that, and I know we have to consider the complainant witness in the community and all of that. I understand that. But I'm advocating for Mr. Smith.
I get it.
Mr. Smith has a final on Monday that he must take. If he does not take this final, and he's again in high school, then he may not graduate. If he doesn't graduate, then we can kiss Baylor goodbye. It's not likely to happen for him in light of all of the challenges that he's dealing with. He doesn't have his mother to help him. His grandmother, we know she's a complaining witness. He can't even go around the house. He doesn't have any help right now. He's living with a friend and walked here from Atascocita this morning, which took him 9 hours. I mean, this situation it's extremely difficult, Judge. So my ask is that we do something, and it could be amend bond conditions, but to keep him on bond so that he can take his test, do what he needs to do to finish school, and hopefully we can resolve these issues. I've looked at the evidence that the state has submitted for the new case. There's clearly something happened, clearly. I mean, and I see the evidence shows that. But if he's walking down the street and this girl, per her own admission, jumps out her car to engage into a physical altercation with him to defend herself, that doesn't make sense. And that's not really fair to him. Someone that's on bond, and everybody knows he's on bond because she said, I knew him. We used to be friends.
He could have walked or run away, gone to a store, called the police. There were a multitude of other options you could have done. You know what's at stake here, yet you pick up another case where you allegedly stomp on someone's head. And you want me to let you go? I understand that you have school. I don't know that you have a final on Monday. Am I supposed to take your word for it? No, you are a danger to my community. You have one assault. You have had violations on bond while you're on that assault, and now you've picked up another assault. You are a danger to my community. And there's only one thing that I need to do, and that's to put you in jail because you refuse to comply with bond conditions. And I've given you over and over. I appreciate your tenacity, and I love that you're defending zealously, but I can't let him go. It would be enabling this behavior and telling him it's okay for you to do what you're doing. And it's not. It's not okay to sit there and stomp on someone's head.
And Judge, we anticipated that possibility. I'd ask in the alternative that you consider a very low bond, as my client has approximately $100 to his name, being a child, in my mind, a person that hasn't even graduated from high school.
State of Texas, what do you think?
Judge, we would be opposed to that. I mean, given the egregiousness of these facts, we believe the defendant is the...
I won't do the normal. What I normally do is I set bonds at $5,001 when you pick up a new case. I'm willing to go down. I'm not going to give them a $100 bond because that's what we do on new cases.
I'd ask
I think that's a little...
So we're going to revoke the previous bond that was a personal bond?
I will only touch the old case.
And so we'd ask that, well, I didn't anticipate that you would set a personal bond on the new case. So I guess my request would be two $500 bonds.
Oh.
I mean, we're talking about a misdemeanor assault between children, not a...
Well, I don't know that. I mean, you're putting in stuff that I have no idea
the state
about.
Alleged a misdemeanor assault. They didn't allege an aggravated assault, which they could have, and they did not. They alleged a misdemeanor assault.
Doesn't make me feel better.
I mean, the state says, alleges that there's all this injury. We can see what the injuries were. You see the complainant witness in a picture. She's smiling.
She go to the
talking
hospital?
to the police. No, she didn't go to the hospital, Judge.
I don't know.
I've read everything. She hasn't gone to the hospital. She has a swollen eye. is what she has.
Judge, I don't believe, I mean, her hair was also ripped out, Judge, based on what we see in the four corners of the dims. We haven't done.
I don't know. I mean, there's a lot of people who wear different types of hair.
Sure.
So,
But just going off the dims, we have her hair being ripped out and being stopped. So,
And to your question, not hospitalized, Judge.
so here's what I'll do.
Judge, just if I may add, even in the first AFM, Judge, the complainant has gone back to the home at least once, to my knowledge, based on my communications with the complainants on that case. The defendant has gone back to the grandmother's homes, contrary to the bond conditions and the no contact orders in that case. He's repeatedly, time and time again, violated his bond conditions, and now so we would be opposed to anything less than $1,000.
Yeah, I know. I would. So what I was going to, his bond on the first assault is it's $1,500. I'll do 2501 on that. Okay, I'll only raise it up at $1,000. On the new case, what do you think?
1,000.
Should we give him a PR bond?
Judge,
No, Judge.
we'd be opposed based on the nature of the allegations where he stomped on someone's head, pulled her hair, and in addition to that being picked up just a month after the previous AFM.
And charged with a misdemeanor. I mean, if the state felt so vigorously about this case, then they would have filed it in district court. I mean, this is a misdemeanor assault between.
I think there's no way this would have been gone upstairs.
I agree, and which is why I think a personal bond could be adequate in light of the fact that he would be given a surety bond on his previous case. He doesn't have much of anything. If anything, that keeps him in jail until we get to trial, because that would be a case that we would set.
All right, Mr. Brooker, I'll set the new one. I'll set it at $500.
Thank you, Judge.
I hope you get it. You're going in today, but I hope you get it. I mean, we're not going to stand for this. You got to pay the piper. And I don't know if it's dealing with the school now will get you to wake up and realize that you can't do what you're doing, but that's it. I've literally bent over backwards not to put you in jail, Mr. Smith. Literally bent over backwards. How many chances have we, Yeah, goes with you. Okay, Mr. Smith, good luck. Hey.
Judge, thank you.
Judge, is that a waive of parents or required?
Wait, yeah. Yeah, I mean, there's no sense in bringing him down. How's jail?
113, waive of parents.
Nothing.
Mr. Smith, we want you to be the best person that you can be, right? And part of what you need to do and what we're here to do is teach you how to grow up, to make better decisions. You have no one that's going to bond you out. These are things that you think about when you go out. If you are hanging around with thugs, people will treat you like a thug. Perception is reality. These are things that you think about when you're out there, whether you're going to a party, whether you're hanging out with other friends who like to smoke weed, whether you're going to a park and you know that there are people that are not good for you and you're still doing that. These are decisions that you need to look at and to think, okay, if I do this now, what potential bad things can happen? I'm on bond for a criminal case and I don't have anyone to bond out. I got a test on Monday, yet when you're out there, always consider the negative of what can happen in every decision you make. You are now in jail. You've missed a test, allegedly, because I don't know for sure. You could be blowing smoke on my puppy. I would never even know, right? Am I supposed to feel sorry for you now that you have 2 assaults?
No, sir. You just doing your job.
Right. But what I want you to do is I want you to learn. And you got 2 assaults and you still haven't learned. So what do we do to ensure that you now, if we let you go out in the street, you're going to make the right decisions? What do we do? Because I don't know. I want to let you out. I don't want to keep you in. But you're your own worst enemy. If I let you out, I know that you're just going to continue to make a bad decision. So we're at an impasse. It's a dilemma. It's a fork in the road.
Situation is a little different today, Judge, after a weekend in jail, seeing how easily Mr. Smith can lose his liberty if he is not 100% compliant with bond conditions. He hasn't just heard it from us now. He's actually experienced it. So that's different. And I would think that that matters to him as he understands how quickly things can change in his situation.
How many times have we put him in jail?
It's only the first time, Judge. We tested him.
We revoked his bond once, am I not?
No, I don't think we have any bond revocations.
Tried it on Mr.
No, we appeared initially and he had a drug test and we had a conversation. You admonished him, but this was the first time that he actually went in.
And how many violations have we had? You know?
It was only the one dirty UA, Judge. At least that we spoke about.
Here's my other, if I were to go send you for a drug test now, what would pop up? It's a rhetorical question. I don't want you to answer. But that's what I'm also thinking about. You know, me, you're in jail, you picked up a new case. I've repeatedly asked you to not smoke weed. You've tested positive already once. If I send you for a test now, what's going to happen? I don't know.
All of that before he had to go to jail. Now he sat in jail and can't get out. There's no way for him to get out. He understands that. So I would think that would change his mindset. He's intelligent and he understands, but still 17 years old has to sometimes hit their head to learn and understand what those consequences really feel like.
Where are you living now?
I still with my best friend in Humble, Temple Square. I just started staying there like 2 days before I came to court.
You don't even have a stable home.
Well, the order and the request of the state was to stay away from grandmom and don't go there and don't ever go back. So he hasn't.
Have any other parental figures out there?
No, sir. I don't really know too much of my family. Yeah, just pretty much. I don't know too much of my family. They really don't want nothing to do with me. So I just be alone.
And just somebody that purported to be Tristan's mother did reach out to me, but indicated that she could not help or didn't want to help because I asked those questions too. Wasn't
Take him in?
No, sir. This was about 2 or 3 weeks ago. So he's truly on his own. Again, the person I've been speaking to purports to live in Georgia and is young himself. Can't come here, can't do anything here. So our hope was that he was able to make bond because it is reasonable. It's a reasonable amount of money, but the bond company won't bond him out without.
But even Mr. Brooker, even if you bond out, if you continue to make the bad choices, you're going to end up right back here over and over and over. You know, he's telling me that you want to plead guilty just to get out. I'm not going to do that because I'm not going to let you ruin your life. Because when you end up with these assault convictions, you're all but ruined. You know, do you think people hire assault convictions? You think you're going to get a job? You think you want to go to school to study this and that? It's all for naught because when you start racking up convictions, life is hard enough as a Black young man in society today as it is. And when you start racking up convictions, it only makes the life more difficult for you. That's hard enough as it is. And you're not getting it through. If I go drug test you now, what is the result? Even after months of me preaching to you not to use. I don't want you to answer the question. What I'm trying to break through to you is that I have repeatedly told you not to use. I've repeatedly I've told you not to hang with dogs because you're going to get fleas and not you caught yourself a damn flea. I don't know. I want to let you out, but I can't trust you.
So where we are with it now, Judge, state made the offer. We understand your position on it, which I thought that would be the case, that you wouldn't accept that plea. So I'd like to move forward as quickly as we can.
Who is the best friend that is you're telling me that you were in the stay with? How old is this person?
She's 18.
And who does she live with? On her own?
No, she stays with her mother. Me and her mother have had a talk about me staying there. And she said that as long as, I do what I continue, well, she said as long as I continue to, keep up with my schoolwork and stuff and, keep going to school. She said she just don't want to let me in her house. So as long as I continue to go to school and stay out of trouble, then I'm good there. And she understands that
If I can verify that there's a parental figure at that house, I will let him out. I'm going to put a monitor on you and I'm giving you a curfew. But if you can somehow verify, Mr. Brooker, that there is an actual adult living there, it's not just an 18-year-old just hanging out, 17 and 18-year-old, then I'm down. But I got to know that there's some kind of adult figure there so that we know there's at least some kind of supervision, not 17 and 18-year-old hanging out with each other, because it's a disaster in the making. I don't want any more disaster. So if you can verify that, I'm down. But I'm going to tell you now, you will be reporting here to me while you're on bond, and I'm going to test you on a weekly basis to make sure that you're not using. The next time you test positive, so help me. Do you understand? You pick up a third case, I'm going to lose it. The little hair that I have left will be gone, because that's how upset I will be. Do you understand? Don't smoke weed, and I want proof that you're enrolled in school full time. Do you understand, Mr. Smith? The only way is that I know that there's a parental figure here, so you have at least some kind of someone watching out. Okay, so we got time. I mean, I'm here. You have my cell phone.
I do.
Right? So just text me, and even if it's 2 o'clock, 3 o'clock, we can work it out.
I'll work on it. Thank you, sir.
Okay.
all right.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.